Hi, everyone. I have the same article from last time, Admissibility of DNA Evidence in Court. And I wanted to read down here on page 14. It's called the Confrontation Clause Challenges to Reliance on Hearsay DNA Reports of Non-Testifying Analysts and to Propriety Expert Systems. Because the rule against hearsay and the Confrontation Clause, the proponent of forensic DNA report cannot offer the report itself into evidence without calling the report's author to the witness stand. However, the proponent of the testimony can circumvent that hearsay rule by having the testifying analyst simply explain to the fact finder that her expert opinion is based on another analysis report. Under Federal Rule of Evidence 703 and its state analogs, so long as the hearsay report itself is not offered as evidence, a testifying expert is free to base an opinion upon hearsay or other admissible evidence. Although the evidentiary rules allow a testifying DNA analyst to rely on another analyst's hearsay report in rendering an opinion, there is still an open question as to whether such testimony might violate the Confrontation Clause in a criminal case if offered against the accused. In Williams v. Illinois, the Supreme Court heard a rape case in which the state's DNA analyst testified that the defendant's PCR-STR profile, which was tested and developed at the testifying analyst's state laboratory, matched the profile developed by the victim's vaginal swabs, which were tested and analyzed at a different laboratory. Cellmark. The defendant argued that the analyst's testimony violated the Confrontation Clause because the analyst's expert's opinion was based in large part on the analysis and conclusions of Cellmark's analyst, who did not testify. A majority of justices of the Supreme Court concluded that the testimony did not violate the Confrontation Clause. But no one argument received a full 5 votes. 4 justices concluded that the non-testifying expert's report did not implicate the clause because it was technically offered only to explain the basis of the testifying analyst's opinion rather than for its truth. In addition, an additional justice concluded that the testimony did not implicate the clause because the hearsay rule report of the non-testifying analyst was not sufficiently formal or solemn to count as testimonial hearsay, given the Cellmark analysis was conducted before a suspect had been identified. Because neither of these theories of admissibility in the Williams garnered 5 votes, and because of the changing composition of the Supreme Court, the Williams decision leaves unresolved whether future DNA cases with slightly different facts might present a Confrontation Clause problem. For example, a recent decision by New York's highest state court reversed a burglary conviction on Confrontation Clause grounds, where the testifying DNA analyst who opined that the defendant's DNA matched the DNA from the crime scene, but who had not conducted, witnessed, or supervised the DNA testing in the case, simply read to the jury the hearsay report of another testifying DNA analyst colleague. The other potential Confrontation Clause challenge to DNA evidence relates to the results of propriety expert systems offered at trial. A reported LR from True Allele is not considered hearsay under American Rules of Evidence because it is not an assertion made by a human witness. True allele is one of those probability programs that when they upload this SNP, they make it digital and the program will run the probabilities. And so this report here is saying that the true allele program is not a human witness. So true allele cannot be placed under oath, cross-examined, or physically confronted. But some contenders have argued that expert systems offering accusatory claims against criminal defendants should perhaps be considered witnesses against. The defendant, for the purposes of the Confrontation Clause, while confrontation of a proprietary algorithm would not be synonymous with cross-examination, it might involve disclosure of a source code, disclosure of prior statements of the algorithm related to the same subject matter, or a right to some sort of technical transparency report that reveals relevant assumptions of the program, such as the program's estimate of allelic dropout rates or stutter percentages at various loci, with the exception of the dissenting California Supreme Court justice. However, no appellate court has yet been persuaded that machine-generated results might implicate the Confrontation Clause. Indeed, at least one U.S. court justice has intimated that raw data from a machine would likely not implicate the Confrontation Clause. The next section here is called the Fourth Amendment Challenges to the DNA Database Cold Hit Results. Now, I remember, is it Bicca Barlow's declaration? She's talking about cold hits. There's a few paragraphs about it. So, thus far, Fourth Amendment challenges to forcible DNA sampling of those convicted of or arrested for certain crimes, the uploading of the resulting DNA profiles to CODIS for comparison purposes have been unsuccessful. Each state, as well as the federal system, maintains a DNA database authorized by statute containing the PCR, STR profiles of people convicted of or arrested for various crimes. I did hear some things that they keep the victim's DNA as well in those, but there hasn't really been much action on that. But I know that there's people out there that feel like the witness's DNA shouldn't also be in there, or the victim's DNA, because during the process of trying to find out the unknown DNA, a lot of times they do use the victim's DNA or innocent people's DNA to find the unknown DNA in that sample. These official statutory databases are all interconnected through CODIS, allowing local police anywhere in the country to compare a crime scene DNA profile to 14 plus million profiles in CODIS to look for a match or a cold hit to an unresolved case. In 2013, the Supreme Court upheld the constitutionality of Maryland's arrestee database on grounds that states can reasonably require arrestees to give DNA for identification purposes, just as they are forced to give fingerprints. Most recently, the California Supreme Court held that California's arrestee database was also constitutional under King, a critical decision, given that California's database differs significantly from Maryland's database in that it does not allow for automatic expungement of the arrestee's record and is more expansive in the crimes it covers. To the extent that the Fourth Amendment challenges to database cold hits might be successful in the future, they will probably relate to more controversial tactics such as familiar searching of genealogy websites, or collection of abandoned DNA. Isn't that interesting? I think we heard almost all of those terms in the Brian Kohberger case. Familial searching entails searching a database not just for a perfect match, but for a partial match, indicating that a person with partiality matching might be related to the perpetrator. While familial searching has been banned in a few states, including Maryland, it is explicitly permitted in 12 states, including California. While proponents argue that the practice helps catch elusive criminals, critics argue that it has significant, radically disparate impact and unfairly allows law enforcement to scrutinize people who are not in a criminal or even an arrestee database in the absence of any suspicion of wrongdoing. No Fourth Amendment challenge has yet been successful against the collection of abandoned DNA, which people inadvertently leave on coffee cups, cigarette butts, and the like. The prevailing logic is that because the DNA has been abandoned, it is akin to garbage, which is devoid of Fourth Amendment protections because the owner has abandoned it and thus has no legitimate expectation of privacy in the contents under existing constitutional doctrine. A Fourth Amendment challenge against government searches of commercial genealogy databases onto which members have voluntarily posted their DNA profiles for comparison with other members might be precluded on the same grounds. California police recently identified a suspect in the Golden State Killer case based on a search of open source genealogy website GEDmatch conducted without a warrant, without probable cause, and in a way that violated the terms of service by creating a fake name associated with the crime scene DNA profile they uploaded for comparison purposes. The Supreme Court decision in Carpenter v. United States might breathe new life into such challenges. However, in Carpenter, the court held that the government cannot subpoena historical cell records without a warrant, even though the defendant had shared his location with his cell phone company. In doing so, the court significantly limited the reach of the third-party doctrine, and a suspect has no legitimate expectation of privacy in information he shares with others. The full implications of Carpenter for DNA database search challenges remains to be seen. So I think that was another court case, the Carpenter one, that was referenced in one of these court filing, the motions on the docket. And also, I do want to say that the Golden State Killer case, he's a serial offender. His semen was found at multiple crime scenes, and that was one where the semen is more potent than touch DNA, so it was easier. There was a lot more information to work with to be able to ID him. The source DNA in the Kohberger case is trace DNA, and so it is not as abundant. And so the cases differ in regards to the type of DNA that is existing in the case. And even though the genealogy was used, there's still two very different cases. And I think a lot of people, they don't realize that. They just go right for the IGG and say, oh, these cases are so similar. No, they have completely different genetic material involved in these cases. And like I said, blood, sweat, semen, saliva. Those are all regularly used types of DNA. They can be very plentiful. They've been used for a while. So those are, you can get more accurate results with those as opposed to the trace DNA, which hasn't been around as long, and we still don't really understand how it transfers. And it has been used for exonerations and cold cases, and I've never heard of an active case where the transfer trace DNA has been used in IgG for an open and active case. There was also one more thing up here. Here's something about admissibility of evidence related to DNA transfer. Under certain circumstances, DNA can transfer from one individual or surface to another, direct transfer, or even from the second person surface to a third person surface, secondary transfer. The likelihood of transfer occurring is a function of a number of factors, including the type of surface touched and whether the individuals involved are shedders or non-shedders. So that is another concern about the DNA in the Koberger case, because we don't know if it was direct transfer or secondary transfer. We don't know if it's actually touch DNA at this point, since we don't know how it transferred. It is trace. And like I said before, it's very difficult to determine how this DNA transfers. So, and the knife sheath is not the murder weapon. So if the coroner testifies to certain types of wounds and certain types of objects that would make those wounds, if it is something that is different than a K-bar knife, then what significance does that knife sheath have? And we don't even know if it belongs to Brian Koberger. I know there's people out there that say he bought it on Amazon, but there's absolutely no proof of that. That is written on in a search warrant, because yes, they actually did the physical search and they processed the paperwork, but that doesn't mean that Brian Koberger actually owned a knife sheath. And that still doesn't mean a knife sheath was the murder weapon, or the murder weapon was the object that goes in there. And I know that people are concerned that the touch DNA was on the snap, but that's where I think we should expect it to be, because if it is secondary transfer, you can wear gloves, and you can have other people's DNA on top of outside your gloves. And what do you do when you're in everyday life? You grab things with your hands. So whoever the perpetrator was, or they could have had somebody else's DNA on the outside of their gloves if they were wearing gloves while they were in the act. And since they're grabbing at things and they're pulling and they're snapping the snap, and they're doing the functions of what it would do if you handled an object like that, yes, it's very possible that if there was DNA on the outside of that person's gloves, that DNA of a person who's not present can travel from the perpetrator's gloves to the snap. And I know that people just think that could never happen, but actually I think that's more likely to happen, because it depends on what kind of shedder you are. If you're the actual perpetrator and you have gloves and you're not that much of a shredder, you may not leave that much DNA. You might actually bring your neighbor's DNA, or somebody you walked by on campus. You're bringing somebody else's DNA into it. So we don't know how that trace DNA got on the metal snap on the knife sheath, and we don't even know who owned that. We don't know if the weapon is that. And I do think it's interesting that the police are not looking for the knife. Is that because the knife is not the murder weapon? I don't understand why they wouldn't be looking for it. I mean, they have time. So I just wanted to get on real quick and say hello to everybody. I haven't seen you in a while, about a week. Yes, I've had a horrible migraine, so I've been around, but I haven't really been feeling up to getting on camera. But I'm back now, over it, so I'm just gonna snap right back to everyday life, and hopefully I will go live soon, maybe later today or this weekend, and I'll get to talk to all of you, which I look forward to. And send me your DNA articles if you want me to go over them. You can find me on Twitter. My Twitter is on my YouTube page. The link will take you right there, and you can message me there. I do have a few other ideas in store, but I will get those videos out as soon as possible, and hopefully I will see you soon on a live. All right, bye.